Okay, so U.S. v. Mezzanatto of 1995, Justice Thomas of the Supreme Court delivered the opinion. Federal Rule of Evidence 410 and Federal Rule of Criminal Procedure 11E6 provide that statements made in the course of plea discussions between a criminal defendant and a prosecutor are inadmissible against the defendant. The court below held that these exclusionary provisions may not be waived by the defendant. We granted cert to resolve a conflict among the Court of Appeals. We now reverse. Respondent Gary Mezzanatto was arrested after selling methamphetamines to an undercover agent. On October 17th of 1991, respondent and his attorney asked to meet with the prosecutor to discuss the possibility of cooperation with the prosecutor agreed to meet later that day. At the beginning of the meeting, the prosecutor informed the respondent that he had no obligation to talk, but that if he wanted to cooperate, he would have to be completely truthful. As a condition to proceeding with the discussion, the prosecutor indicated that respondent would have to agree that any statements he made during the meeting could be used to impeach any contradictory testimony he might give at trial if the case proceeded that far. Respondent conferred with his counsel and agreed to proceed under the prosecutor's terms. Respondent then admitted knowing that the package he had attempted to sell to the undercover police officer contained methamphetamines prior to his arrest. Initially, respondent also claimed that he was acting merely as a broker for another trafficker, Gordon Schuster, and did not know that Schuster was manufacturing methamphetamines at his residence, but he later conceded that he knew about Schuster's laboratory. Respondent attempted to minimize his role in Schuster's operation by claiming that he had not visited Schuster's residence for at least a week before his arrest. At this point, the government confronted respondent with surveillance evidence showing that his car was on Schuster's property the day before the arrest. The meeting on the basis of respondent's failure to provide completely truthful information. Respondent eventually was tried on the methamphetamine charge and took the stand in his own defense. He maintained that he was not involved in the methamphetamine trafficking and that he had thought Schuster used his home laboratory to manufacture plastic explosives for the CIA. He also denied knowing that the package he delivered to the undercover officer contained methamphetamine. Over defense counsel's objection, the prosecutor cross-examined respondent about the inconsistent statements he had made during the October 17th meeting. Respondent denied having made certain statements, and the prosecutor called one of the agents who had attended the meeting to recount the prior statements. The jury found respondent guilty, and the district court sentenced him to 170 months in prison. A panel of the Ninth Circuit reversed over the dissent of Judge Wallace. The Ninth Circuit held that respondent's agreement to allow admission of his plea statements for purposes of impeachment was unenforceable, and the district court therefore erred in admitting the statements for that purpose. Federal Rule of Evidence 410 and Criminal Procedure 11E6 rules or pre-statement rules are substantively identical. Rule 10 provides, except as otherwise provided in this rule, evidence of the following is not in any civil or criminal proceeding admissible against a defendant who was a participant in plea discussions. ... For any statement made in the course of plea discussions with an attorney for the prosecuting authority which do not result in a plea of guilty. The Ninth Circuit noted that these rules are not subject to only two express exceptions, neither of which says anything about waiver, and thus concluded that Congress must have meant to preclude waiver agreements such as respondents. In light of the precision with which these rules are generally phrased, the Ninth Circuit declined to write in a waiver in a waiverless rule. The Ninth Circuit analysis is directly contrary to the approach we have taken in the context of the broad array of constitutional and statutory provisions. Rather than deeming waiver presumptively unavailable, absent some sort of express enabling clause, and we instead have adhered to the opposite presumption. The presumption of waivability has found specific application in the context of evidentiary rules, absent some overriding procedural consideration that prevents enforcement of the contract. Courts have held that agreements to waive evidentiary rules are generally enforceable even over the parties' subsequent objections. And there's a lot of citation there, but courts have liberally enforced agreements to waive various exclusionary rules of evidence. Note, contracts alter the rules of evidence. Thus, at the time of the adoption of FRE, agreements as to the admissibility of documentary evidence were routinely enforced and held to preclude subsequent objections as to authenticity. And although hearsay is inadmissible except under certain specific exceptions, we have held that agreements to waive hearsay objections are enforceable. Party stipulation. It cites a bunch of cases. Party, and in parentheses, party stipulation to admissibility of contract. Admissibility of document precluded hearsay objection at trial. Indeed, evidentiary stipulations are a valuable and integral part of everyday trial practice. Prior to trial, parties often agree in writing to the admission of otherwise objectionable evidence, either in exchange for stipulations from opposing counsel or for other strategic purposes. Both the federal rules of civil procedure and the federal rules of criminal procedure appear to contemplate that the parties will enter into evidentiary agreements, including during the pretrial conference. During the course of the trial, parties frequently decide to waive evidentiary objections, and such tactics are routinely honored by trial judges. It is left to the parties in the first instance to decide whether or not the rules are to be enforced. It is only in rare cases that the trial judge will exclude evidence they are content to see admitted. More cases here. The cases, case law, Tupman, Thurlow, Co. vs. SS Cap Castillo, U.S. Of 1974, U.S. vs. Wing of 1971, Sac and Fox Indians of Mississippi and Iowa vs. Sac and Fox Indians of Mississippi and Oklahoma, 1911, U.S. vs. Bonnet, 1989, U.S. vs. Coonan, 1991, criminal defendant not entitled to evade the consequences of an unsuccessful tactical decision made in welcoming admission of otherwise admissible evidence. There may be some evidentiary provisions that are so fundamental to the reliability of the fact-finding process that they may never be waived without irreparably discrediting the federal courts. And Wright and Graham is being cited a lot. See also Wheat versus U.S., 1988. Court may define a defendant's waiver of his right to conflict-free counsel. United States versus Josephic, 1985. No doubt there are limits to waiver if the party stipulated to trial by 12 orangutans. The defendant's conviction would be invalid, notwithstanding his consent, because some minimum of civilized procedure is required by community feeling, regardless of what the defendant wants or is willing to accept. But enforcement of agreements, like respondents plainly, will not have that effect. The admission of plea statements for impeachment purposes enhances the truth-seeking function of trials and will result in more accurate verdicts. Under any view of the evidence, the defendant has made a false statement either to the prosecutor during the plea discussion or to the jury at trial. Making the jury aware of the inconsistency will tend to increase the reliability of the verdict without risking institutional harm to the federal courts. Respondent also contends that waiver is fundamentally inconsistent with the rule's goal of encouraging voluntary settlement. We need not decide whether and under what circumstances. So this is like a new analysis here. Looks like it doesn't get a lot of weight considering the common law analysis is so overwhelming. We need not decide whether and under what circumstances substantial public policy interest may permit the inference that Congress intended to override the presumption of waivability. For in this case, there is no basis for concluding that waiver will interfere with the rule's goal of encouraging plea bargaining. Although the availability of waiver may discourage some defendants from negotiating, it is also true that prosecutors may be unwilling to proceed without it. Prosecutors may be especially reluctant to negotiate without a waiver agreement during the early stages of a criminal investigation when prosecutors are searching for leads and suspects may be willing to offer information in exchange for some form of immunity or leniency in sentencing. In this cooperation context, prosecutors face painfully delicate choices as to whether. So public policy, it's like reverse public policy concern, I guess, from the prosecution standpoint, which rarely looked at. They may not offer it, maybe too early to offer it, extend leniency or full immunity to some suspects in order to procure testimony against other, more dangerous suspects, against whom existing evidence is flimsy or non-existent, from Hughes, 1982. Because prosecutors have limited resources and must be able to answer sensitive questions about the credibility of the testimony they receive before entering into any sort of cooperation agreement, that the testimony provided may be used for impeachment purposes. If prosecutors were precluded from searching such agreements, they might well decline enter into cooperation discussions in the first place and might never take this potential first step toward a plea bargain. Respondent asserts that there is a gross disparity in the relative bargaining power of the parties to the plea agreement and suggests that this is a bad argument. And suggests that a waiver agreement is inherently unfair and coercive. The dilemma flagged by respondent is indistinguishable from any of a number of difficult choices that criminal defendants face every day. The plea bargaining process necessarily exerts pressure on defendants to plead guilty and to abandon a series of fundamental rights. But we've repeatedly held that the government may encourage a guilty plea by offering substantial benefits in return for the plea. Corbett v. New Jersey, 1978. The mere potential for abuse of prosecutorial bargaining power is an insufficient basis for foreclosing negotiation altogether. Rather, tradition and experience justify our belief that a great majority of prosecutors will be faithful to their duty. Newton v. Rumery, 1987, plurality opinion. Thus, although some waiver agreements may not be the product of an informed and voluntary decision, the possibility does not justify invalidating such agreements. Instead, the appropriate response to respondents' predictions of abuse is to permit case-by-case inquiries into whether waiver agreements are the product of fraud or coercion. We hold that absent some affirmative decision, indication that the agreement was entered into unknowingly or involuntary, and agreement to waive the exclusionary provisions of the plea statement rules is valid and enforceable. Accordingly, the judgment of the Court of Appeals is reversed. And so Ginsburg, O'Connor, and Breyer join concurring. Sauter and Stevens are dissenting, and I'm not reading them. Their opinions.